everyone. So today we're going to get a little more philosophical than normal. That's because this case is a little more deep than normal. So tell me, does the fact that I now have MS and my life has changed a bit diminish the value of my life monetarily? That's kind of the issue the court faced in this case. Let me give you some background before we hear the hearing. This is a case that stems from the Muskegon Circuit Court. Marcus L. David as a personal representative of the estate of Willie Mae Turnage v. Quincy Hall and Total Care Transportation. On July 17, 2019, the decedent, Willie Mae Turnage, was being transported for dialysis treatment by defendant Quincy Hall, who was employed by defendant Total Care Transportation, LLC. The decedent required assistance getting to dialysis because she had been in a wheelchair since 2018 after experiencing weakness in her legs for several months, had previously been diagnosed with dementia, and had 3 strokes in 2018 and 2019. On the return trip from the dialysis center, Hall encountered a railroad track and brought the transportation van to a stop. Hall claimed that as he was applying the brakes, he heard a noise from the back of the van and turned to see the decedent sloped out of her wheelchair and noticed the security strap had worked itself from her waist underneath her armpits. Hall stated that he was able to re-secure the decedent, who did not complain of any injury, and he returned her to her home. The plaintiff, who is the decedent's grandson, testified, however, that when Hall and the decedent returned home, Hall told the plaintiff that he forgot to secure the strap around the decedent, and she fell forward out of her wheelchair. Plaintiff stated that shortly after returning home, the decedent complained of leg pain as plaintiff was placing her in bed. It was then discovered that the decedent's left femur was broken. Ouch. The decedent was immediately taken to the hospital and underwent surgery. The decedent made a full recovery after approximately 2 months, but later died from complications related to COVID-19. The plaintiff subsequently brought this suit on behalf of the decedent's estate, seeking to hold the defendants liable under theories of negligence and vicarious liability. The defendants moved for a summary disposition under MCR 2.116C10, arguing that because the decedent was already wheelchair-bound and suffering from dementia, plaintiff could not show that the injury to the decedent's leg impaired her ability to lead a normal life. The trial court agreed, stating, she was in a wheelchair. When she was at home, she could do there was no indication that her hands or that she couldn't do the puzzles because of the broken femur. She's in a hospital. She's doing therapy. She's doing what she needs to do. She's on pain medication. Because she had a broken femur, it didn't stop from visiting and having communications with family and friends in that form of her life. And because, it's the dementia is there, and she's had that, and it goes back and forth, reading and looking at the affidavit and all of the information that I have, I just don't see that it has met the threshold of an impairment of a bodily function. After the trial court entered its written order granting defendant's motion, plaintiff moved for reconsideration, which the trial court also denied. This appeal followed. So the Michigan Court of Appeals, the 5th panel, reviewed this case. This is the oral argument in front of them.
Well,
Okay.
We are really crushing it today. How about we go to 15? Going once, going twice. Okay, so I'm going to call the 15th case for today. Docket number 367950, Estate of Willie Mae Turnage v. Quincy Hall. Good, we have attorneys. Please.
Good morning, may it please the court. Matthew Swartz on behalf of the plaintiff appellant, estate of Willie Mae Turnage. Your honors, I know you've read the materials. This is legally speaking anyways, a very straightforward case. And so while normally I would have a brief oral presentation, I certainly will have a few points to make. I'd like to start by asking the panel if there are any particular questions that you all have for me before I point out a few things.
Any questions?
No, I don't.
Thank you. So very, very briefly, and I understand the court's prefacing comments. Just to point out a few things, in terms of the current version of the applicable statute, just to point out some specific language that I want to focus the court on. The current governing statute, MCL 500.3135, sub 5, sub C, again, codifying the McCormick case, specifically the language about the third prong, which is what we're here to talk about, because the other two prongs of the McCormick analysis were conceded or admitted, so to speak, for purposes of the motion in the trial court. Again, for purposes of MCL 500.3135, an injury affects a person's general ability to lead his or her normal life. All that means is that it has had an influence on some of the person's capacity in his or her normal manner of living. And then, of course, it goes on to talk about the temporal considerations being relevant, but no express temporal requirements. Here, comminuted fracture, left femur, open reduction, internal fixation, more than a month and a half in hospital and or inpatient skilled nursing. Ms. Turnage, obviously before her death, she was in her 90s. She had multiple medical conditions, and certainly that's not disputed. However, she was living at home. She was having some interaction with her friends, her family, having some independence in her wheelchair. Even though, obviously she had a stroke, she had some diminished cognitive ability. She was engaging in activities commensurate with her age and her abilities. She was completely unable to do that while she was in the hospital and in the acute nursing home. Even after being back, because of problems with transfer, her ability to even get out of bed, be transferred to a wheelchair, to have that degree of independence was very limited until she got very sick with a stroke and other conditions in the fall of 2019. So by and large, what we have here is a credibility issue. What we have here is conflicting facts about the medical condition, conflicting facts about the recovery and her state before and after the accident. And because of that, we believe that the summary disposition of the trial court was inappropriate and that the issue is best left to the jury to decide.
Okay. Why don't we do this? Why don't we hear from the other side, and then you'll have plenty of time for rebuttal.
Good morning, Carol Smith on behalf of the defendant appellees. I need to comment on the comment that you just heard about this being a matter of credibility issues and conflicting facts. The only thing that we have here that creates a credibility issue or conflicting facts is the affidavit of Susie Davis, Ms. Turnage's daughter. Now, the plaintiff is an estate. The personal representative of the estate testified to a number of facts that absolutely supported summary disposition on this threshold issue. So I need to point out the case law that I cited in my summary, being the Klein case.
Before we get into all the case law, how does breaking her leg, being in the hospital, and even when coming home, being much more significantly limited than what she was even before, how does that not affect her general ability to lead her normal life?
There hasn't been sufficient evidence that she was
well, she had a broken leg. I mean, she had a normal life. She had, a normal life for a 90-year-old. Prior to that, I understand she was, limited in her mobility. But I mean, she was in the hospital. She was much more. I think it's a fair inference from the facts in the record that she was much more severely limited in her movement when she got home than when she was before. I mean, how is this not a fact question and you're just arguing about damages?
No, so it does sound like a significant injury and impairment. And for any of us in this courtroom, it would be, because the statute requires us to compare this particular individual's life before this incident to this particular individual's life after this incident. And before this incident, She was in and out of hospitals.
Because this really bothers me what the trial court did here in a way. Because it's like, the whole position is like, her life is so bad, it doesn't matter if it got worse, because it was always, it's so bad. Her normal life is so bad that it can't get any worse, so therefore, there's no injury, threshold injury, and I just don't see that.
Well, and I disagree that that's why the trial court came to the ruling that she did. And that certainly is not what I was trying to argue. But-
So, I mean, I don't think Judge Kelly's view is unreasonable. So what were you arguing if that's not the argument you were making?
My argument is that there has to be a change. Pain is not enough. We know that. We have a series of unpublished cases that dealt with broken bones and surgeries and stuff. That is not enough. We need to compare what she was doing on a daily basis, what she was doing in her daily life before, to what she was doing in her daily life after. And there is not a meaningful change there. She was in and out of the hospital. She was in and out of nursing homes. She was not able to walk. She was not able to even wheel herself around in her wheelchair. None of that changed. Her daily activities just simply did not change. And with the advanced dementia, I mean, even though the pain isn't really relevant to this threshold analysis, even if it were, she had dementia so advanced that when you look through the medical records that I cited and attached, most of the time she didn't even understand that she had an injury. She didn't know why she was in the hospital.
I think that's a very dangerous argument to make. And just because somebody has dementia or Alzheimer's doesn't diminish the value of their life. And I think you're making a case for damages, the way I see it. You know, maybe her damages are not significant compared to, you know, a 20-year-old who has a similar injury. But I mean, she was in the hospital before she was at home. That is in my opinion, that is a significant change in her life.
Well, and the other thing too, the other part of my argument here is, why was she in the hospital? Obviously, part of that was due to the femur, but if this was a woman that simply had the femur and no pre-existing, she might have been in and out same day. She might not have ever actually been hospitalized. So a lot of the changes in her life that have been argued by the plaintiff, by the estate, there hasn't been any, besides from the family testimony, there hasn't really been anything.
But I mean, that may be all there is, but that's not nothing. I mean, if they provide testimony under penalty of perjury, that's as good as we got. Again, I think I just keep hearing damages arguments.
Is there any other questions that the court has of myself? Okay, thank you for your time.
Brief rebuttal.
Unless the panel has any further questions for me, I have.
Good call.
Thank you.
Thank you.
Thank you.
Case is submitted.
Not long after the hearing, the Court of Appeals issued their written decision. And this was their analysis. On appeal, plaintiff argues that the trial court erred when it granted the defendant's motion for summary disposition because there was a genuine issue of material fact whether the decedent's injury affected her ability to lead a normal life. We agree. An individual is, quote, subject to tort liability for non-economic loss caused by his or her ownership, maintenance, or use of a motor vehicle only if the injured person has suffered death, serious impairment of bodily function, or permanent serious disfigurement. And that's quoting MCL 500.31351. The term serious impairment of bodily function means under the statute that the impairment that satisfies all of the following requirements. A, it is objectively manifested, meaning it is observable or perceivable from actual symptoms or conditions by someone other than the injured person. B, it is an impairment of an important body function, which is a body function of great value, significance, or consequence to the injured person. C, it affects the injured person's general ability to lead his or her normal life, meaning it has had an influence on some of the person's capacity to live in his or her normal manner of living. Although temporal considerations may be relevant, there is no temporal requirement for how long the impairment must last. This examination is inherently fact and circumstance specific to each person, must be conducted on a case-by-case basis, and requires comparison of the injured person's life before and after the incident. See also McCormick v. Carrier. 3 prongs are necessary to establish a serious impairment of bodily function. 1, an objectively manifested impairment. 2, of an important bodily function that, 3, affects the person's general ability to lead his or her normal life. Under the first prong, whether there is an objectively manifested impairment, the plaintiff must present evidence of actual symptoms or conditions that someone other than the injured person would observe or perceive as impairing a bodily function. The second prong, whether the impairment is of an important bodily function, is an inherently subjective inquiry that must be decided on a case-by-case basis because what may seem to be a trivial bodily function for most people may be subjectively important to some, depending on the relationship of that function to the person's life. And under the third prong, the common understanding of to affect the person's ability to lead his or her normal life is to have an influence on something, the person's capacity to live in his or her normal manner of living. By modifying normal life with his or her, the legislature intended that this requires a subjective, person and fact-specific inquiry that must be decided on a case-by-case basis. Determining the effect or influence of that impairment has had on the plaintiff's ability to lead a normal life necessarily requires a comparison of the plaintiff's life before and after the incident. In Piccione v. Gillette, the injured claimant, a 3-year-old boy, was in a motor vehicle accident in which he broke his left shoulder. The boy was given a sling and medicine for the pain and physically recovered after 3 or 4 months. The trial court entered summary disposition in favor of the defendants, concluding that because the boy was able to make a full recovery, the injury did not rise to the level of a serious impairment to that body function. This court reversed, stating that a jury could conclude that Gavino's general ability to lead his normal life was affected by the impairment. We noted, in this case, Gavino was a 3-year-old child at the time he suffered the impairment. His parents testified that as a result of the impairment, he was unable to go to school for approximately 2 weeks, and that when he did return to school, he was unable to use the play equipment. Additionally, they testified that after the accident, they had to help him go to the bathroom, including by carrying him to the bathroom. His father testified that before the accident, Gavino could dress himself, but afterwards he could not. There was also testimony that Gavino needed help going up and down the stairs because his balance was negatively affected by his impairment. Further, at times, his ability to sleep without pain was also compromised. His father testified that on occasion, Gavino would wake up complaining about shoulder pain. The record also reflects that before the accident, Gavino liked to color, but after the accident, he did not want to do so. And before the accident, he rode his bicycle, played soccer, and played with his scooter in the basement, but after he was injured, he was unable to do so. His mother testified that Gavino was cautious about physical activities after the accident. The court also highlighted that a person's ability to lead his or her general life does not have to be destroyed in order to constitute a threshold injury. It only needs to be affected. Thus, the fact that the boy had made a full recovery did not foreclose his ability to recover under the statute. As in Piccione, in this case, there was a question of fact whether the decedent was able to lead a normal life after the injury. Although it is undisputed that the decedent was in a wheelchair and was generally immobile before the accident, the evidence presented by the plaintiff showed that after the accident, the decedent's life was negatively affected. The decedent's daughter, Susie Davis, stated that before the accident, the decedent was able to get out of bed under her own power, but as a result of the accident, she could no longer move herself without assistance. Similarly, plaintiff testified that the decedent had difficulty doing her exercises and was not as engaged as she was before the accident. Contrary to the trial court's conclusion that the injury did not affect her life because both before and after the accident, she was still in a wheelchair and wasn't up for running around, the testimony from both plaintiff and Susie raised an issue of fact whether the accident affected the decedent's mobility and general life after the accident. Similarly, the trial court erred when it concluded that because the decedent had a broken femur, it didn't stop her from visiting and having communications with family and friends in that form of her life. To the contrary, Susie claimed that the decedent was confined to her bed and could not spend time with her family or outdoors as she did before the accident, both because of her need to be hospitalized and the extreme difficulty moving her. Defendants appeared to make the argument that because the decedent was able to make a complete recovery, her ability to lead a normal life was not affected. This argument is unpersuasive, however, because the fact that the decedent was able to make a full recovery within 2 months of the accident is not dispositive. The argument is unpersuasive because the fact that the decedent was able to make a recovery within 2 months of the accident is not dispositive. Although temporal considerations may be relevant, there is no temporal requirement for how long an impairment must last. Defendants also argue that the evidence that the decedent was suffering from a variety of complications and illnesses before the accident required entry of summary disposition on their behalf. While it is true that before the accident the decedent was wheelchair-bound and had general lower extremity weakness that required physical therapy, there was no evidence that the issues worsened as a result of the accident. Both plaintiff and Susie described the decedent's decrease in energy and inability to accomplish tasks, such as getting out of bed as a result of the accident. Although defendants argue that these impacts are de minimis, the statute simply requires that the injury affected the decedent's ability to lead a normal life. In sum, plaintiff presented sufficient evidence to create a genuine issue of material fact whether the decedent's injury affected her ability to lead a normal life, and the trial court erred when it granted defendant's motion for summary disposition on the issue. Reversed and remanded for further proceedings consistent with this opinion. We do not retain jurisdiction. Plaintiff is the prevailing party, may tax costs. Judge Schwartzel, Judge Kelly, Judge Young. Interesting. I will keep this on my calendar. It might be a while because I checked, and surprisingly, it has already been scheduled for a hearing, a jury trial, for July 28th, 2025. So I'll see you then.